Welcome back to the deep dive. We're taking a deep plunge today into what happens when a company reaches, well, the end of its operational life. The complex process of company liquidation, also known as winding up.
Yeah, really crucial stuff.
Absolutely,
hmm
especially if you're navigating company law for study purposes. Now, we're incredibly grateful for the source material that's made this deep dive possible. It's generously made available for educational purposes by the University of London. So, a big thank you to them.
Here, great resources.
And this deep dive is proudly brought to you by Sinorbit Academy, Sri Lanka. To all of you out there preparing for your exams, we really do wish you the very best of luck.
Yes, good luck, everyone. And liquidation, it's essentially the legal mechanism for closing a company down, selling off assets, paying off debts. It's that formal process before the company totally ceases to exist.
And it brings a whole lot of specific legal issues with it,
Yeah.
especially for creditors and directors.
Exactly. It's not just closing the doors. There are strict rules.
Okay, so our mission today, using this excellent material, is to really demystify company liquidation. We want to unpack the different ways a company can be wound up,
Mm-hmm.
understand how the process is designed to protect creditors, those who are owed money, and crucially explore the significant implications this can have for company directors.
Yeah.
Potential liabilities, restrictions, the lot.
Yeah, the aim is to make the key concepts, the legal sections, the important cases, and, the core facts really stick. Especially for those exams, we'll focus not just on the steps, but why they matter.
Perfect. So let's start right at the beginning. What exactly is liquidation or winding up? And how's it different from, say, dissolution? They sound pretty similar.
They are related, definitely, but distinct. Think of liquidation or winding up as the active process. It's the period where a professional liquidator takes charge,
Okay.
gathers the assets, sells them, and distributes the cash according to strict legal rules. Dissolution, on the other hand, that's the final
All right,
result.
the end point.
Exactly. When the liquidation's done, everything's settled, the company's name comes off the register, it legally ceases to exist. So liquidation is the job you do before you get to dissolution.
Got it. Liquidation, process, dissolution,
Yeah.
equals final end. And the main law governing all this is?
That would be the Insolvency Act 1986. You'll hear us mention it a lot, the IA 1986.
Yeah, in 1986. So what kicks this whole thing off? How does a company actually end up in liquidation?
Okay, so the IA 1986 sets out the main triggers. And for exam purposes, it's really useful to get these clear because they often decide the type of liquidation. There are three main
The
routes.
three main ones.
Yes. First, the company's own members, the shareholders, can decide to wind it up. That leads to what we call voluntary winding up.
Okay, the members choose.
Second, creditors can go to court and petition to force the company into liquidation, usually because it can't pay its debts. That's compulsory winding up.
Forced by creditors. Right.
And third, sometimes the Secretary of State can ask a court to wind up a company if it's in the public interest.
Voluntary, compulsory, public interest. Are there any others we should quickly mention?
Well, there is a fourth ground, Section 122(1) GIA 1986, where a member petitions because it's just and equitable. But honestly, it's less common in the scenarios we're focusing on today, which are usually about financial trouble or, public concern.
Okay, let's stick with the big three then. Starting with voluntary winding up. So this is the company choosing this path itself.
Pretty much. It's started by the company's members, usually by passing a special resolution. That's laid out in Section 84 IA 1986 S.84.
But why would members choose this? Especially if the company's actually doing okay. Wouldn't they just sell their shares?
That's a really sharp point. It highlights the two main situations for voluntary winding up. One is when the company is actually solvent, but maybe the members just want to stop. Perhaps it's a retirement thing or a project's finished.
Right.
They want to sell the assets and share out the cash. But as you said, selling the shares is often better tax-wise for shareholders. So winding up a solvent company, while possible, it's less common. You might remember the Regal Hastings case from other discussions. Shareholders often look for the best financial exit, and that might not be liquidation if the company's healthy.
So if winding up a solvent company isn't that common, the other reason must be the main driver.
Yes, exactly. The more frequent reason for a voluntary winding up is when the company is facing insolvency. The directors, the members, they see the writing on the wall. They realize the company probably isn't going to make it.
So they jump before they're pushed, maybe.
Sort of. They choose to start the process themselves, maybe to manage it better, cooperate with creditors, or sometimes, yes, maybe to try and limit their own personal liability for things like wrongful trading by acting proactively.
Okay, so voluntary winding up can be For solvent or insolvent companies, does the actual process change depending on that?
Hugely. This is a really key distinction to get your head around. Voluntary winding up splits into two completely different tracks based purely on solvency.
Right.
If the directors genuinely believe the company is solvent, meaning it can pay all its debts in full within 12 months, they can make a formal legal statement, a statutory declaration, under Section 89 IA 1986.
Section 89, the Solvency Declaration.
Exactly. If they can make that declaration, it triggers a member's voluntary winding up. And because the creditors should get paid in full, the members stay largely in control. They appoint the liquidator. So remember, members' voluntary winding up is for solvent companies.
Okay, solvent means members are in charge. What if it's insolvent?
If the directors cannot honestly make that solvency declaration because the company is insolvent, then it becomes a creditor's voluntary winding up. No declaration under S.89. And in this case,
Creditors take over.
pretty much.
Yeah.
The creditors effectively control the process. They usually choose the liquidator because, well, it's their money most at risk. So creditors' voluntary winding up is for insolvent companies.
Makes total sense. Solvency dictates the path and who holds the reins.
Absolutely. But in either type of voluntary winding up, the liquidator's basic job is the same. Get control of assets, sell them, realize them, pay off liabilities, settle them, and if in a creditor's voluntary there's anything left over, distribute the surplus to members. Then eventually the company heads towards dissolution. That's covered in sections 91 and 107 IA 1986.
Okay, clear on voluntary. Let's move to compulsory winding up. This one sounds, well, forced.
It is. This is usually started by someone outside the company, most often a creditor, petitioning the court. And the most common reason, under Section 122(1) IA 1986, is simply that the company is unable to pay its debts.
Unable to pay its debts, okay.
So a compulsory winding up is typically triggered by a creditor because the company can't pay what it owes.
Now, unable to pay its debts, does the law get more specific than that? Or is it just, obvious?
Oh, the law is very specific. And it's a very wide definition under Section 123 IA 1986. Section 123. This section basically captures two different ways a company can be legally insolvent.
Two ways. What are they?
Okay, the first is what's called cash flow insolvency. That's under Section 123(1). It means the company can't pay its debts as and when they fall due.
So, like, immediate bills,
Yeah.
paying salaries, suppliers.
Exactly. It's about short-term liquidity. The Act gives three specific ways a creditor can show this to the court. 1, serve a formal written demand for a debt over £750, and if it's unpaid for 3 weeks, that's proof, unless the debt's genuinely disputed.
Okay.
2, if a creditor gets a court judgment and tries to enforce it, like sending bailiffs, but they come back empty-handed.
Right.
Or 3, if the court is just generally satisfied, based on the evidence, that the company can't pay its debts as they fall due. So cash flow insolvency can't meet current obligations.
And the second type of insolvency under Section 123.
The second type, in Section 1232, is balance sheet insolvency. This looks at the bigger picture, the longer term. It means the total value of the company's assets is less than the total amount of its liabilities.
Including potential future debts.
Yes. Crucially, it includes contingent and prospective liabilities debts that might crop up later or depend on something happening. So, balance sheet insolvency is when, overall, the company owes more than it owns. Assets less than liability.
Wow. So a company could be wound up compulsorily if it fails either the cash flow test or the balance sheet test. Just one is enough.
Precisely. Just one is enough. And this very broad definition in S123, well, it makes it relatively easier for creditors to bring a petition, which is good for them.
But maybe tough on a company having a temporary blip.
It can be, yes.
Yeah.
A company might have valuable long-term assets but just face a short-term cash squeeze. There are some safeguards, though. The court always has discretion under Section 195 IA 1986.
The court doesn't have to wind it up.
No. It might refuse if, say, most other creditors oppose it, maybe thinking administration or something else offers a better chance of getting paid. And we had those temporary CIG 2020 restrictions during the pandemic, but they're mostly gone now.
Okay. And in a compulsory winding up, who's the liquidator?
Initially, it's the official receiver. That's a government official, a civil servant. But if there are enough assets to make it worthwhile, the official receiver usually calls meetings of creditors. And the creditors then typically vote to appoint their own choice of liquidator, usually a private insolvency practitioner. That's under S.1364 IA 1986.
Right. Creditors get their say. Okay, we've done voluntary, we've done compulsory. What about that third one? public interest winding up?
Yes, this one's quite different. It's under Section 124 AIA 1986. This allows the Secretary of State to petition the court to wind up a company if it's considered in the public interest.
Public interest. So not necessarily about being broke.
Exactly. Insolvency is not required for this type. It's usually triggered after an investigation reveals serious misconduct, maybe fraud, dodgy dealing, or just a complete lack of commercial honesty.
So it's the government stepping in to stop bad actors, basically.
Precisely. The source mentions cases like Re-Driver Time Recruitment Ltd. and Re-UK Eurogroup Plamic both involved fraudulent activity. It's about protecting the public from scams or harmful business practices.
Makes sense. Okay, so regardless of how it starts voluntary, compulsory public interest, once a company is in liquidation, how does the actual process work to protect those creditors?
Right. This is where the liquidator really steps up. As soon as that winding up order is made or the liquidator is appointed in a voluntary winding up, the director's powers cease. They're out.
They lose control completely.
Yes. The case Measures Bros Ltd v. Measures is often cited for that directors lose their management authority. It transfers to the liquidator. And importantly, the liquidator takes on fiduciary duties, similar to directors, to act honestly and in the company's best interests. But now those interests are focused on the winding up itself. The case Silkstone and Haymore Colco v. Edie touches on this.
So the liquidator takes the reins, but with a different goal, winding things down fairly.
Exactly. Their main job, under S143IA 1986, is to realize the company's assets, sell everything off, and then distribute the money according to that strict legal priority order. And they get pretty wide powers to do this under S167 and Schedule 4 of the Act.
Realizing assets is selling what the company owns. But you mentioned earlier they can also swell the pot, bring more money in. How does that work?
Yes, this is crucial for creditors. Liquidators can actually go after money or assets that aren't currently on the company's books. They can challenge past transactions or pursue claims, especially against directors.
Like clawing back money.
Exactly. For instance, they can sue directors for breaches of duty that happened before liquidation, or use the summary procedure under Section 212 IA 1986 for misfeasance.
Okay.
They can go to court to undo transactions at an undervalue. That's Section 238 IA 1986. If the company sold something too cheaply in the 2 years before winding up, they might be able to get it back or recover the difference unless the company was solvent at the time.
So selling assets cheap just before the end is a no-no.
Generally, yes. They can also attack preferences under Section 239 IA 1986. This is where the company deliberately paid off one creditor ahead of others just before liquidation, putting them in a better position.
Like paying off a bank loan the directors personally guaranteed.
That's a classic example, yes. They can also challenge extortionate credit transactions and invalidate certain recent floating charges if they seem unfair. And, very importantly, they can bring actions against directors personally for wrongful trading, Section 214, or fraudulent trading, Section 213.
We'll definitely come back to wrongful and fraudulent trading. But first, once the liquidator has gathered all this money, sold assets, clawed back value, how do they decide who gets paid? Is there a queue?
Oh, absolutely. A very strict queue, a legal hierarchy of payment. It's definitely not first come, first served.
Who's at the front?
First dibs go to creditors with fixed charges over specific assets. They get paid from selling that specific asset.
Okay, secured creditors first. Then what?
Then, from the general pot of money, the order is 1. The costs of the winding up itself, the liquidator's fees, legal costs, etc. 2. Preferential debts. This includes certain employee wage arrears and pension contributions. The government used to be preferential for taxes, but mostly gave that up in 2002.
Right.
3. Creditors with floating charges. But their payout is now subject to that ring-fenced fund carve-out we need to talk about. 4. Ordinary unsecured creditors. This is your typical trade supplier, HMRC, for most taxes now. Customers owed refunds, the general body of creditors.
They seem quite far down the list.
They are. And finally, 5. Any deferred or subordinated debts that were specifically agreed to be paid last.
So what happens to those ordinary unsecured creditors if the money runs out before it gets to them, or only covers a fraction of what they're owed?
That's where the pari passu principle kicks in. Pari passu, it means on an equal footing. If there isn't enough money to pay all the ordinary unsecured creditors in full, they share what is available proportionally. Everyone in that group gets the same number of pence in the pound for what they're owed.
Right. Equal misery for the unsecured creditors if there's a shortfall. You mentioned floating charges used to potentially sweep up everything.
Yes, historically, a bank with a floating charge over all the company's assets could often take almost everything remaining after costs and preferential debts, leaving little or nothing for the unsecured creditors. It was a big issue.
Did the law change that?
It did. The Enterprise Act 2002 brought in a really important reform with Section 252. It created something called the ring-fenced fund, sometimes called the prescribed part.
Ring-fenced fund, what does that do?
It means the liquidator has to set aside a slice of the money realized from assets covered by a floating charge. That slice, that ring-fenced amount, is specifically earmarked for the ordinary unsecured creditors. It gets paid to them before the floating charge holder gets the rest.
Ah, so it guarantees some return for the unsecured creditors from those floating charge assets.
Exactly. It provides a minimum pool for them. The amount depends on the value realized, up to a cap currently £800,000. It was a trade-off. Remember I said the state gave up most of its preferential status. That helped fund this ring-fenced pot for unsecured creditors.
Interesting. A clear balancing act there. Complex stuff. Selling assets, applying these rules. How do we know they're doing it properly and fairly?
Good question. They're heavily regulated. First off, they have to be a qualified insolvency practitioner licensed by a professional body. That's in Section 233 IA in 1986.
So they need specific qualifications.
Yes, and remember, in compulsory liquidations and creditors' voluntary liquidations, the creditors themselves usually get to choose the liquidator. That gives them significant control and oversight. Plus, as we mentioned, liquidators owe fiduciary duties.
Okay, so there are checks and balances on the liquidator. Let's shift focus now squarely onto the directors. When a company goes into liquidation, it must have huge personal consequences for them.
Oh, absolutely huge. The source material really flags two main areas of impact. First, intense scrutiny of their past conduct leading up to the insolvency with potential personal liability.
Okay, looking back.
And second, serious restrictions on their future business activities, looking forwards.
Let's take past conduct first. We touched on the liquidator suing for breach of duty or recovering assets. What are the really big-ticket liabilities directors face, specifically linked to trading while insolvent?
The two key ones you absolutely need to know for exams are wrongful trading under Section 214 IA 1986 and fraudulent trading under Section 213 IA 1986. They sound similar, but they're critically different.
Okay, break down wrongful trading, 214 for us first. What does that involve?
Right, wrongful trading. This applies if, at some point before the company went into insolvent liquidation, a director knew, or crucially ought to have concluded, that there was no reasonable prospect the company could avoid that outcome.
Ought to have concluded. So even if they didn't actually know, but a reasonable director should have known.
Precisely. It's an objective test based on what a reasonably diligent director with the skills they have or ought to have would have realized. If the court finds wrongful trading occurred, it can order the director involved to personally contribute to the company's assets, essentially pay for the extra losses creditors suffered because the company kept trading when it shouldn't have.
Is there any way out for a director if they did realize things were hopeless but kept going for a bit?
Yes, there's a defense. A director can avoid liability for wrongful trading if they can prove to the court that from the moment they knew, or to have known, things were beyond rescue, they took every step they reasonably could have taken to minimize the potential loss to creditors.
Every step to minimize loss. Sounds like a high bar.
It is, and the source highlights the case Brooks v. Armstrong, which confirmed the burden of proof is entirely on the director to show they took those steps. They have to convince the court.
Okay, so wrongful trading, knew or should have known it was doomed, liability, unless you prove you did everything possible to limit the damage. Got it. What about fraudulent trading, S213? How's that different?
Fraudulent trading is much, much harder to prove. It requires showing that the business was carried on with the intent to defraud creditors or for any other fraudulent purpose.
Intent, so deliberate dishonesty.
Exactly. It's about actual fraud, not just poor judgment or negligence. Because it mirrors a criminal offense under S.993 Companies Act 2006, the standard of proof needed, even in a civil claim by the liquidator, is very high, close to the criminal standard. So fraudulent trading, S213, needs proof of intent to defraud. Section 214, wrongful trading, was brought in largely because proving that intent versus 213 was just too difficult in many cases.
Right, so S214 captures negligence or incompetence in letting things get worse, while S213 is for actual deliberate fraud.
That's a good way to put it. The source does mention that liquidators can be hesitant to bring either claim sometimes because they're complex and expensive. But
But there are other ways directors might be held accountable.
yes, a couple of important developments. One is the power for liquidators to assign these claims, basically, sell the right to sue for wrongful or fraudulent trading to a third party under Section 246 ZDIA 1986. That third party might have deeper pockets or more appetite for the fight.
Interesting. Selling the claim itself.
And the other, potentially more impactful route now links to director disqualification. It's the introduction of compensation orders under Section 15A of the Company Directors Disqualification Act 1986, CDDA 1986.
Compensation orders.
Yes. If a director gets disqualified for unfit conduct, and that conduct specifically caused loss to creditors, the court can now, alongside the disqualification, order the director to personally pay compensation to those creditors, given that disqualification happens more often than successful wrongful trading claims.
This could be a more common way for directors to face financial consequences for creditor losses.
Potentially, yes. It directly links the finding of unfitness to making good the harm caused.
Okay, that covers the scrutiny of past conduct. What about the other area restrictions on future activities?
Right. Even if a director avoids personal liability, liquidation can still seriously impact their future career. One specific rule is the same name prohibition under Sections 216 and 217 IA 1986.
Same name prohibition.
Yeah. If you were a director of Company X Ltd. when it went into insolvent liquidation, you're generally banned for 5 years from being involved with any new company called X Ltd. or something so similar it sounds connected, like X Trading Ltd.
Ugh. Stops them just closing down, wiping debts, and starting the exact same business again the next day under the same banner.
Exactly. It tackles that Phoenix Company issue where the name itself carries goodwill.
Makes sense. What else?
The biggest restriction is the risk of disqualification itself under the Main Company Directors Disqualification Act 1986, CDDA 1986. We mentioned compensation orders linking to this, but the disqualification itself is the primary sanction. Directors of any insolvent company automatically come under scrutiny. If their conduct is found to be unfit, they can be banned from being a director or involved in managing any company for between 2 and 15 years.
Unfit conduct. That sounds serious. How is unfitness judged?
The source points to the classic test from Relo Line Electric Motors Ltd. The court said it's not about mere commercial misjudgment, bad decisions happen. Unfitness involves something more serious. A lack of commercial probity, honesty, gross negligence, or total incompetence. It's a significant deterrent.
So, directors of failed companies really do risk personal financial hits and being barred from future directorships. It definitely puts pressure on them to act responsibly, especially when things get tough financially.
That's certainly the intention of the framework.
Okay, this has been incredibly comprehensive. As we start to wrap up, thinking specifically about our listeners studying for exams, how should they pull all this together? What are the absolute must-know takeaways?
Right, exam focus. Good idea. I'd say concentrate on understanding the main concepts and linking them to the key laws and cases. First, nail the types of liquidation. Voluntary, members versus creditors, know the difference. Know the S.89 IA 1986 solvency declaration is key. Compulsory, creditor petition, usually unable to pay debts under S.123 IA 1986, remember cash flow versus balance sheet definitions. And public interest, S.124A, no insolvency needed, usually fraud.
Types and triggers. Got it.
Second, the liquidation process as creditor protection. Know the liquidator's role, measures bros, silkstone cases. Their power is to swell the pot, especially setting aside transactions at undervalue, S23A, and preferences.
Okay, liquidator's job and powers.
Third, and this is critical, master the priority rules for distribution. Fixed charges first, then costs, preferential, floating charges, but subject to the ring-fenced fund, then ordinary unsecured, then deferred. Know the pari passu principle for unsecured creditors, and understand why that ring-fenced fund from S252 Enterprise Act 2002 exists to help unsecured creditors get something.
Priority, pari passu ring-fenced fund. Crucial.
Finally, the implications for directors. Really understand wrongful trading. S214 IA 1986. The test, you ought to know, no reasonable prospect. The defense, minimize loss, Brooks v. Armstrong case on onus, and how it differs from fraudulent trading, S213 IA 1986, which needs intent to defraud. Also know the future restrictions, same name prohibition, SS216 217 IA 1986, and the big one, disqualification under the CDDA 1986 for unfitness reload line test, plus those linked compensation orders, S115A CDDA 1986.
Okay, director duties, liabilities, and restrictions.
Yes. And crucially, try to see the connections. Why does the law allow preferences to be challenged? To support the pari passu principle? How does the threat of S21 free influence director behavior? It pushes them to consider creditor interests earlier. Explaining the why and the how these pieces fit together shows real understanding.
That's fantastic advice. Focus on the connections and the rationale, not just rote learning. Thank you so much for breaking all that down.
My pleasure. It's a complex area, but seeing how it fits together makes it, well, slightly less daunting, hopefully.
Definitely. And once again, our sincere thanks to the University of London for making the source material available for educational use, and huge thanks to Sinorbit Academy Sri Lanka for bringing you this deep dive. We really hope this has helped clarify things and given you a solid base for your studies. And you just reflect on all this, the different ways companies end, the rules for sorting out the finances, the pressures on directors. Here's a final thought to mull over. The law is clearly trying to balance lots of competing interests in liquidation. You've got creditors wanting their money back, directors facing scrutiny, the need for an orderly shutdown. Does the current system, with its priority rules, its clawback powers, its director accountability rules like wrongful trading and disqualification, does it strike the right balance? Or even with all these rules, are there still situations where some parties, maybe smaller unsecured creditors, maybe employees, maybe even directors trying their best, end up getting a raw deal? Something to think about as you continue your studies. Keep digging, keep questioning. And for those upcoming exams, you've got this. Good luck.